Good morning, Your Honors.
Good morning.
Brett Chase, on behalf of the appellant Hector Jimenez Sales, I'd like to reserve 5 minutes for rebuttal.
All right, thank you, sir.
The argument presented today can be summed up as follows. The Circuit Court reversibly erred by failing to make an inquiry and factual determination as to whether Mr. Jimenez Sales sufficiently understood Spanish, and or reversibly erred by failing to provide Mr. Jimenez Sales with an interpreter that spoke the Mayan Mam language after Mr. Jimenez Sales indicated he did not understand Spanish very well and requested an interpreter that speaks the Mayan Mam language.
And you know that the briefing has centered around the fact that your client has acknowledged repeatedly through his entire odyssey through the court system that he was a Spanish speaker. He had previously had Spanish interpreters with which he had no problem. And there was never any indication that this was an issue at all until this moment of truth at trial, where he decides he doesn't understand Spanish and now needs a Mayan Mam interpreter. Help us, sort through that. At what point do we have to sort of say, look, if he was having a language problem, he should have told everybody many hearings ago when he was very happy with an interpreter and his own lawyer spoke Spanish and they appeared to have no trouble communicating with each other.
Yeah, I don't think there's anything that says he has to make the court aware at a certain point in time that he's having problems with his interpreter.
Why not? Why not? How's the court supposed to know? How's the court supposed to know? We were all three trial judges. Every time there was a language barrier, they let us know. Because what I see in this record is Mr. Rondon represented him for over a year. When it got to trial, he didn't even bring him street clothes. And then he brings up a Mayan interpreter, the necessity of a Mayan interpreter. The court says, wait a second, let me look at this docket. He's been through all kinds of proceedings.
The court didn't look at the docket.
Hold on, not finished. With Spanish interpreters, when the judge says to Mr. Rondon, have you and your client meet with these two interpreters here in the courtroom, Mr. Rondon declined. Mr. Rondon only met with Mr. Sales. He never met with those two interpreters to allow the court to be able to be told that my client understands these interpreters. He excluded them from that conference. And then he tells the court, we can go forward, but my client doesn't understand. And I don't see anywhere in the rest of this record throughout this trial where he ever notified the court that there was a language barrier. Don't get me wrong. We appreciate the nature of your argument and the ramifications of not understanding it when you're a criminal defendant and due process. But there's nowhere in this record where Mr. Rondon told that trial court at any recess, my client doesn't understand and my client is unable to assist me in his defense. Show me.
So at the beginning of the trial, the first couple of pages, Mr. Rondon and Mr. Jimenez Sales tell them that he's having a problem with Spanish, that he doesn't fully understand Spanish, and that he's having issues with it. Regarding these pretrial hearings, you got to keep in mind, this is Mr. Shanko's first day on the case. He didn't look into any pretrial.
Judge Shanko?
Judge Shanko, I apologize.
Yeah, but Judge Shanko tells Mr. Rondon to meet with the interpreters and Mr. Sales. He declines. The interpreters are excluded from that little meeting. And then Mr. Rondon tells the court he doesn't understand. What kind of showing is that?
Well, again, all that matters is that Mr. Jimenez Sales made the court aware that he didn't understand Spanish, and Judge Shanko just didn't do anything about it. He did no inquiry. He had no idea of Mr. Jimenez Sales' comprehension. He didn't ask the interpreters that were there. He didn't ask the trial counsel how he's been communicating with them, how well that communication has been going.
And why didn't Mr. Rondon, in between each and every witness, inform the court, my client does not understand? That never happened. It never happened.
That would just be distracted to the court and everybody else.
It's not a distraction, sir. That's a due process issue.
Exactly. He made the issue known to Judge Shanko that Mr. Jimenez Sales does not understand Spanish language, that he doesn't feel comfortable going forward in Spanish.
That was before they picked the jury. After they picked the jury, they accepted the jury, and he never told Judge Shanko that my client didn't understand voir dire. My client didn't understand any of what the jury said. He said my client's okay with this jury. Let's move forward.
the judge had already made it clear that he was not going to get a Mayan MAM interpreter, that he was not going to delay the trial proceeding whatsoever.
But your client himself had told the court on several occasions that he spoke Spanish. So, you know, I mean, it's a troublesome thing. I speak Spanish, and now the day of trial, when he really doesn't want to go to trial, gee, I don't speak Spanish, I need a different interpreter. I mean, can you imagine a judge being a little bit concerned about that?
Sure, but that doesn't mean he shouldn't make an inquiry as to whether or not Mr. Jimenez-Sales does speak Spanish.
But he wasn't given the opportunity because his lawyer below did not allow the interpreters who were present to try to engage him in conversation so that they could take a position on whether or not he could or could not understand them. I mean, I think, as everybody knows, there are many dialects of Spanish, and your client clearly has demonstrated some proficiency in that language. And there may be some dialects that he understands better than others. We'll never know because these interpreters were never given an opportunity to find that out.
Right. Well, I mean, that's my issue here, is that the interpreters weren't asked about anything that they've discussed with him in the past. I don't see how that was on Attorney Rendon. The inquiry should have happened as soon as Mr. Jimenez-Sales made the court aware that he wasn't understanding the Spanish interpreters. Ultimately, when a defendant makes the court aware that he's having a language difficulty, the court should engage in an inquiry as to whether or not he understands, normally it'd be the English language, but in this case, it'd be the Spanish language. So in this instant case,
excuse me, sorry.
In the instant case, the circuit court reversibly erred by denying Mr. Jimenez-Sales the interpreter that speaks the Mayan MAM language, despite the fact that they were put on notice. The court then further erred by denying Mr. Jimenez-Sales an interpreter that spoke the language without making any sort of inquiry into Mr. Jimenez-Sales' understanding of the Spanish language, and without making a factual determination as to whether Mr. Jimenez-Sales' lack of knowledge of the Spanish language prevented him from communicating.
Well, you've tried some criminal trials, right?
What's that?
You've tried some criminal cases, right?
No, we only do appeals here.
Okay, well, you've reviewed them. You get up at JOA. You talk about the issues, how the state hadn't proven a prima facie case, but if this language barrier is still evident, you inform the judge of that at JOA. Then when your client gets ready to testify and the judge goes through the colloquy with him, with those interpreters that were present, you inform the court he doesn't understand. But that didn't happen because when the court went through the colloquy with him before he testified to make sure that he was making a free and voluntary decision without any coercion or duress or force to testify on his own and exercise his constitutional right, there was no issue. The attorney said nothing. The defendant said nothing. Nothing about a language barrier at all. So we look at this objectively. So if this was a permeating issue throughout this trial, it would have arisen after, pre-trial before they picked the jury. It didn't.
So the court has been made aware of what the issue is. I don't know of any requirement that an attorney has to keep on repeating what his issue is with the court's ruling.
But you're arguing he didn't get a fair trial because he didn't understand any of it.
Well, we don't know if he understood any of it because there was no inquiry.
Well, I think we do, because if you look at his pleadings for the belated appeal, he did it all with a Spanish interpreter, and he never mentioned the language barrier in all of his pleadings post-conviction.
So that was a pro se motion that after he'd already been denied his request for a Mayan interpreter. Why would he think he would get a Mayan interpreter now when he didn't get one when he had an attorney?
Well, but he was able to draft all of his post-conviction pleadings with the help of a Spanish interpreter then, too.
Okay. That doesn't mean that he understood it sufficiently at trial. That's after trial. It's got nothing to do with this trial. Back to the argument, we believe that, once the court was made aware, they should have made an inquiry. They failed to make an inquiry. That's unquestionable that they failed to make an inquiry. And that the due process and confrontation rights of Mr. Jimenez-Sales were violated. Consequently, we believe that his case should be remanded for a new trial where he is given either an inquiry as to his knowledge of the Spanish language or where he is given an interpreter that speaks the Mayan language. Thank you.
Okay, thank you.
It please the court. Pamela Papasoff on behalf of the appellee, the state of Florida. Your honors, the issue here is whether the trial court abuses discretion by denying appellant a Mayan interpreter during trial when the record shows that appellant understood, spoke, and competently communicated in Spanish and was provided with Spanish interpreters at trial. Appellant is essentially arguing that his due process rights were violated. And while it is true that a defendant has the right to be meaningfully present in the courtroom, and meaningfully present in the courtroom entails that he be aware and know what's going on around him so that he can assist in his own defense, appellant had that here. Why? Because as I've said, a review of the record shows that appellant understood, spoke, and competently communicated in Spanish. And he had 2 Spanish interpreters translating for him the trial. Now, before I get into the specifics of where in the record we find support for that, I'd like to address appellant's argument that there was some great difficulty, that the translator had great difficulty understanding the appellant at trial. Because first of all, the record shows no such thing. The record shows 3 separate instances as outlined in appellant's initial brief in which the proceedings do stop in order for the interpreter to clarify a term. In only one of these does the interpreter actually say she's having a little trouble understanding the witness's Spanish. If one reviews this portion of the transcript, which is pages 566 to 570, it shows that there was an explanation for this misunderstanding. Appellant's counsel objects to the interpreter's translation, and the sidebar discussion that takes place suggests that the interpreter may not be familiar with the particular word that the appellant was using to describe an immigration youth detainment center. Regardless, however, the trial court found that that line of questioning and answer was not relevant, so any misunderstanding as to that particular point does not support the argument that the interpreter in general could not understand him. As to the other 2 instances, as we've been discussing, there's different Spanishes. Spanish has the language, the words that are used can vary from country to country, and even within a country, from region to region. So clarification of a term could be evidence that the interpreter is doing a really good job. The job of the interpreter is to translate exactly what the witness is saying word by word. And so if we think about these word variations, I'll give you an example. In English, there's regional variations. For example, if you're ordering a carbonated drink, Northerners will order a soda. In the Midwest, they order a pop, and Southerners prefer to order a Coke. Everybody knows that one, but there's some that are not as widely known. Did you know that sprinkles, those colorful little embellishments of cupcakes, are known as jimmies in New England? Well, I didn't.
I know that.
But if the appellant in this case had said the morning of the accident that he was going to pick up some jimmies, a good interpreter that was not privy to that regional knowledge would have had to stop the proceeding in order to determine what jimmies meant before she translated for the court.
Ms. Papasoff,
Yes.
as I read Mr. Sales's testimony, and I could be wrong, was there ever a time when he was on the stand testifying that he didn't understand the question? Or was it an issue with his responses where the interpreters didn't understand? Was there ever a time when he took the stand that he did not understand any questions from the prosecutor or any questions from the defense attorney?
No, that was not clear. The only 3 issues as shown in the transcript had to do with the interpreter stopping to clarify a term. And that was the only thing. Now, as to the specific parts in the record that show that he was he had competent knowledge of Spanish. First, we can start with his actions before trial. And I think we've discussed a couple of these, but at first appearance, he requested a Spanish interpreter. Through all the pretrial proceedings, he was provided with a Spanish interpreter. There's also the fact that the defense counsel communicated with the appellant in Spanish and not Mayan. Then after trial, which was also brought up, appellant requested an interpreter for the evidentiary hearing for his belated appeal. Then, and I think it's important to focus on the communications that he had in Spanish with the other trial witnesses. At the scene, he spoke to Trooper David Rodriguez, and Trooper David Rodriguez testified that he was fluent in Spanish, and he was able to speak to appellant and translate for EMS. Appellant was able to give him a description of where he was injured for treatment purposes, and he provided Trooper Rodriguez with his Guatemalan ID when asked. Then there was Trooper Daniel Castilla, who met with the appellant at the hospital. He also testified that he was a fluent Spanish speaker and that he communicated with the appellant without a problem. Appellant told Trooper Castilla that he was the driver and that he was undocumented. Then, and I think this one's important too, Homicide Detective Corporal Hector Suarez testified that he communicated with the appellant in Spanish and there were no language barriers. This one's important because Corporal Suarez was the homicide detective and he went to the hospital to try to get a statement from the client. And when he advised the appellant of his Miranda rights, appellant invoked his rights and declined to provide a statement for the homicide report. So there was some competent understanding of Spanish there. Finally, when the appellant was on the stand himself, he testified that witness Mr. Gallegos spoke to him in Spanish at the scene, and that thanks to him, he was able to communicate with the police. So that's from his own words. In sum, the trial court didn't abuse his discretion by denying appellant this last-minute request for a Mayan interpreter, when the record shows that he clearly understood, spoke, and competently communicated in Spanish, and he was provided with 2 Spanish interpreters. Unless the court has any further questions, the state respectfully requests that this court affirm appellant's conviction and sentence.
Thank you very much.
So one of the major issues that, and it's just kind of getting glossed over here, is that Mr. Jimenez Sales indicated he had problems speaking Spanish, understanding Spanish, and then there was just no inquiry made. An inquiry must be made when the court is made aware of a language difficulty. There's no ifs, ands, about it. And it's reversible error not to have this inquiry or factual determination as to whether or not Mr. Jimenez Sales spoke sufficient Spanish to proceed forward. I mean, in some, this court has previously found that our system of justice has evolved too far for a defendant's acknowledged language problem to cause him to be placed in a position before the court which is not equal to that of an English-speaking defendant in terms of communicative opportunities. The trial court's actions here caused Jimenez Sales to be placed in a position before the court which was not equal to that of an English-speaking defendant in terms of communicative opportunities. Consequently, this court should remand Mr. Jimenez Sales' case for a new trial, where he is provided with an interpreter that speaks the Mayan language, so that his due process and confrontation rights may be properly realized. Thank you.
Thank you both very much. Very well argued. Our next case is Meritus Construction versus HOA of Horatio South Town.